My Lord,
Yes.
I would like to seek your Lordship indulgence in making a mention with regards to part 2, item number 3. This case may be taken up this coming Thursday, 20.
Mr. Malhotra is there?
Yes,
Yes, my Lord.
Okay.
Obliged.
Your Worship, I have a similar prayer in this item 4. If this can come up on Friday then.
Friday. Okay.
My Lord, item number 12, part 2.
Yes.
With the consent of the other party, we are seeking time to convince the parties to settle the matter to Lok Adalat, my Lord. So, time may be given,
How much time?
3 weeks' time, my Lord.
3 weeks.
3 weeks.
Who's for the other side?
Mr. Laldin Liana.
He's not around?
He's not around, but I am taking his consent, my Lord.
You've taken his consent?
Yes, my Lord.
Okay, Mr. F. Liana, learned counsel for the appellant, submits that the parties are making an attempt to settle the matter out of court and therefore prays that the matter be adjourned for 3 weeks. Full stop. He submits that he has also taken the consent of the learned counsel for the other side. Next para. In view of above, matter stands adjourned for 3 weeks. Yes.
Your Lordship, item 6 and 7, hearing list. This may be taken up next week because, Your Lordship, I have been directed to file an affidavit regarding the query raised by this Honorable Court. So I'll be filing within this week.
Mr. Malhotra? Item 6 and 7, as
Yes.
paid for by Mr. B. Ramenga, learned counsel for the respondent number 4. This is the matter again in the next week.
Much obliged.
My Lord, with regard to part 2, item number 1,
Yes.
even though I have taken adjournment in the last court date, I'm being led by Mr. P.S. Deka from Guwahati. They have requested me to make a mention. On 28/4, if it can be listed on 28/4.
Next
matter
month?
is-
Next month?
Yes, my Lord. They have some difficulty to appear today.
Okay, Mr. Malhotra.
It's okay, Your Worship.
What is his name? P.S. Deka.
P.S. Deka.
Please write down. Item 1, hearing list. Mr. Silal Fakzuala, learned counsel for the respondents.
1 and 2.
Submit that he is led by Mr. P.S. Deka, senior counsel from Guwahati. And since he has some personal difficulties, he prays that the matter may be adjourned and be listed on 28th of April 2025. Full stop. The said prayer is not objected to by Mr. Malhotra, learned counsel for the petitioner.
Much
Full stop.
obliged.
Next para. In view of above, list this matter for hearing on 28th of April 2025.
Obliged.
And my Lord, item number 10, my Lord, of part 2. My Lord, I have taken the consent of the other side, my Lord. If this matter can be taken up tomorrow, my Lord.
Okay.
And my Lord, item number 8 and 9. If it's possible, we'll try to do this on Thursday, my Lord. If it's not possible, then it will be in the list.
Okay.
Obliged, my Lord.
May I please, Your Lordship?
Yes.
Part 2, item number 5, my Lord.
Yes.
My Lord, if this matter may be taken up on Friday.
Okay.
Oblige.
Daily list for orders, item number 7.
May it please Your Lordship,
Yes.
case report has been received and paper book is required for that.
Mr. Bila Ramenga,
Yes, my
you were
Lord.
there for the respondents?
Yes, my Lord.
Mr. Zodin Puyanamte, learned counsel for the appellant, and Mr. Bilal Ramenga, learned counsel for the respondents, are present. And they submit that the LCR has been received and paper book will be required. First up, in view of above, registry to prepare paper book at the cost of the appellant and list the same for orders once it is ready.
Much obliged.
Item number 8.
My Lord, even though there is quite a delay in the IA, but my Lord, I admit that no notice was issued while issuing airship certificate to the respondents. So this Honorable Court may pass appropriate order as it deemed fit, my Lord.
Then what about the appeal?
This is about the appeal
What about the appeal?
with regard to issue of airship certificate against the respondent.
No, I'm asking him.
Yes.
If you agree that there was no notice, can the appeal also be sent back?
Send back, my Lord.
right. Okay. Heard Mr. Lal Pianfil Achongthu, Learned Counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 897 days delay in filing the connected appeal. To stop. Referring to the application, the Learned Counsel submits that delay was on account of late knowledge about the airship certificate issued to the respondent, and that once the same came to his knowledge, he took necessary steps to prefer an appeal and to stop. Therefore, it was due to this reason that the delay is occasioned. Next para, Mr. C. Tlantianglima, Learned Counsel for the respondent, submits that should I record no objection?
No, my Lord.
Okay. Submits that although the respondent has not filed objection to the application, but it appears that the applicant took his own time to file the connected appeal, even after having knowledge about the airship certificate. Full stop. He, however, submits that under the facts and circumstance, court may consider and pass appropriate order as it deems fit. Next para, upon hearing the learned counsels for the parties and upon perusal of the materials available on record, this court is of the view that the delay in filing the connected appeal should be condoned, particularly having regard to the fact that the airship certificate which is challenged has been issued without prior notice to the opposite party. First up, in view of above, the delay of $897 days in filing the connected appeal stands condoned. IA is disposed of. Next para. In the main appeal, I heard Mr. Lal Pianfil Achongthu, Learned Counsel for the appellant, and Mr. C. Tlantianglima, Learned Counsel for the respondent,
I'm appearing as a legal aid counsel, my Lord.
who appears as a legal aid counsel. Stop. Learned Counsel for the appellant submits that this appeal has been filed challenging the orders dated 21/2022 and 11/11/2022 by which heirship certificate number 27 of 2022 was issued to the respondent by the Court of Senior Civil Judge, Roman II, Aizawl, without giving any opportunity to the appellant to raise objection or make his claim on the property in question. First of the learned counsel submits that if notice was issued by way of newspaper publication or even by making the appellant as a party respondent, the respondent would have raised his objection to the application, since he has a better claim to the property in question. How are you related to the property owner?
Daughter,
Since the appellant is the daughter of the
unmarried daughter.
since is the unmarried daughter of the deceased. What is his name, deceased? Who died?
Father. Oh, sorry, my lord. My lord, I am challenging two heirship certificates. In Roman 1 is the order dated 21/20/22. Herein the
And the other one? You said two heirship certificates.
Yes.
Where are they?
in Roman number 4, dated 11/11/2022. In heirship certificate number 856 of 2022. It means that on in heirship certificate number 27 of 2022, two properties were there. LSC number 65 of 1983.
Okay, just tell me, you are the unmarried daughter.
Yes,
And who is the respondent?
my sister and brother.
Sister and brother. They
Yes.
are all brothers, sisters.
Yes, but my
All of you are siblings.
yes,
My lord, respondent number 1 is the mother, but since she had died, she's represented by his daughter and his son. And respondent number 2 is the brother of the appellant, my lord. The appellant and the respondent number 2 are brothers and sisters. Respondent number 1 is the mother of the appellant. And the property owner is the father.
Who is the father?
Noon Liana.
Please read the last line. Deceased. Then you write his name. Sri Noon Liana. Stop. He therefore submits that the two impugn orders dated 21/2022 and 11/11/2022 granting heirship certificate number 27 of 2022 and 1856 of 2022 to the respondent should be set aside and the appellant be given an opportunity to raise his objection. Next para. Mr. Seetlan Thianghima, learned legal aid counsel, appearing for the respondent, submits that it appears that no notice was issued to the appellant or any other interested person prior to issuance of the heirship certificate. And therefore, under this circumstance, court may consider and pass appropriate orders as it deems fit and proper. Stop. Upon perusal of the materials available on record, there is no indication that the appellant had been given a chance to oppose the heirship certificate application submitted by the respondent before the Court of Senior Civil Judge, Aizawl. And such being the position, the principles of natural justice has been violated, and therefore court is of the view that the matter should be reconsidered by the learned court below by giving due opportunity to the parties interested in the property in question to stake their claim, STAKE, stake their claim. Stop. In view of above, the orders dated 21/2022 and 11/11/2022, granting heirship certificate number 27 of 2022 and number 1856 of 2022, respectively, are hereby set aside. Stop. The matter stands remanded back to the learned Court of Senior Civil Judge. Which Senior Civil Judge?
True, my lord.
No. 2.
My lord, the first heirship was granted by Senior Civil Judge 2, and the second was granted by Senior Civil Judge 4, my lord.
So where should it go then? Back to the same courts?
Back. Same court, my lord.
Yes, yes.
Two different courts, my lord.
But my lord, in the order dated 21/2022, on page Roman 2, it is Senior Civil Judge 2, but in the heirship certificate, in the seal, it bears Senior Civil Judge 4.
Okay, anyway, what did I say? And remanded back to the Court of Senior Civil Judge,
2.
Aizawl, for consideration afresh by giving due opportunities to the parties concerned to submit their respective claim. You write Senior Civil Judge Aizawl, Senior Civil Judge concerned, okay? You just add one more, Senior Civil Judge concerned, Aizawl. Any LCR has come?
No, my lord.
No, my lord.
You are the legal aid counsel,
My lord.
so what will happen then?
My lord, if a date may be fixed, then I can inform my client, my lord, for appearance.
Okay. Since the parties are represented before this court today, they are directed to appear before the court concerned on suggested date.
On the
Next
Third-
Monday,
3rd April.
3rd April.
Yes, next Monday, 24th.
24th will be fine.
Lord.
I think 1 week is there. Appear before the court concerned on 24th March 2025, along with a copy of this order, whereafter the learned court below shall proceed with the matter in accordance with law and make an endeavor to dispose of the matter as expeditiously as possible after hearing the parties concerned. With the above observation, direction, appeal stands disposed of.
Obliged, my lord.
Item number 9.
Yes.
Your Lordship, I appear on behalf of my senior as Manuel Sheta. So due to some medical emergencies, cannot attend to this. So if
When?
it may please the court, the matter may be taken up next week.
Next week.
Yes, sir.
Now, why is it listed today? On the last occasion, notice was issued. What about the CD?
No, my lord.
You don't have the case diary.
No, my lord. We didn't call for the case diary.
Why shouldn't we have the case diary? This is a bail application, isn't it? You produce the case diary.
Yes, my lord. I
Okay, Mr. S. Vanalfi at the Learned Council for the applicant is said to have some personal difficulties to appear before the court today. On a prayer made on his behalf, list the matter again after a week
Yes, yes, Lordship.
on a date to be fixed by the registry. The learned public prosecutor, Ms. Vanesyami, shall produce the case diary on the next date.
For admission, item numbers 1 to 5.
My lord, in this case, my lord, in this case, my lord, last occasion, my lord, the Additional Advocate General of Mizoram took time, my lord, for personal difficulties, my lord. Again, it was fixed on 27th of this month, 27 March, my lord. So may I pray this 7th of April matter be fixed again, my lord, because on 27th of April, the division branch fixed this matter for hearing, my lord.
On which date?
Coming 27th of March, it was adjourned, my lord, up to, my lord, fixed, my lord, fixed the 27 March 2025.
Okay.
My lord, Additional Advocate General Mizoram, my lord, took time for personal difficulties, my lord, on last occasion, my lord. So may I pray this matter may be fixed on 7th of April, my lord.
7th of April, you said.
Yes, my lord.
Mr. Malhotra?
It's okay.
No objection, my lord.
Please write down. Mr. S.K. Mehdi, learned CGC, appearing through VC, submits that writ appeal number 265/2023 is fixed to be, is scheduled to be listed on 27th of March 2025, and therefore the instant case may be posted on 7th of April 2025. Most of the learned counsels appearing for the opposite parties have no objection to the prayer. In view of above, list this matter again on, list these matters again on 7th of April 2025.
Highly agree.
Item number 6.
Since Your Lordship has condoned the delay, this is the first time it has come up before Your Lordship.
What is this matter?
This matter is with regard to the order which did not allow us to go for the appeal, readmit the appeal. That is 30/10/2023. It has refused to readmit the appeal on the condition that we did not appear in the court dates. So the condonation delay, which was filed along with the RFA, was dismissed due to default. Now, my lord, I'll take Your Lordship to the impin order here, my lord. There is at page 22. This is the order which we have challenged. Before coming to this court by way of FAO, we have first approached RSA before this honorable court against the order 27/7/2023. But however, as per the judgment of this court, we filed an appeal against the order 30/10/2023.
Just a minute. You had come to this court earlier.
Yes, my lord, by way of RSA.
Against which order?
Against the order 27/11/2023. 27/7/2023.
27/7/2023.
27/7/2023. That is arising out of CMA number 160 of 2023 in RFA number 5 of 2023.
CMA number 160
of 2023. Arising out of RFA number 5 of 2023.
25.
RFA 5.
Oh, 5.
Of 2023. RFA 5 of 2023.
So this you've challenged by filing RSA.
RSA.
Okay, is the order dated 27/7 available?
Yes, my lord.
Where is that?
Page 43 of the appeal memo, my lord.
43. RFA.
Yes. FAO, my lord. RFA. The order is RFA dated 27/7/2023 in, along with,
Passed in RFA 5 of 2023.
yes, my lord. And CMA number 160 of 2023 is at page 39. 39 to 41,
39 to 41.
my lord. So basically, it was due to continuous absence that the CMA and the RFA was dismissed.
CMA, what is CMA was?
CMA 160 of 2020.
This was for what?
RFA, this is for condonation of 934 days. In filing an appeal against judgment and order dated 5/8/2020 in money suit 138 of 2018.
Okay, let's start from the beginning.
My lord,
You are the plaintiff or the defendant?
I am the defendant.
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 Money suit, what is the money suit
Money
number?
suit 138 of 2018
138
of 2018.
was filed by the respondent.
Yes, my lord. Was decreed ex parte in favor of the respondent herein.
When?
5/8/2020 is the judgment and order.
5/8/2020.
Yes, my lord. Now, after passing of the said impugned judgment and order, we have filed an application, CMA number 213 of 2020. CMA number 213 of 2020.
213,
Yes, my lord.
2023.
2020.
Okay, this is for what? Setting
For
aside
setting
ex parte.
aside the ex parte under Order 9, Rule 13. Now, it was rejected, that CMA. It was rejected via order dated 7/12/2021.
7/12.
7/12/2021. Now thereafter, an appeal.
Go and type it out. We'll call you.
Thereafter, my lord, an appeal was filed before this Honorable Court, RFA number 19 of 2022, and with IS Civil 80 of 2022, IS Civil 80, my lord.
This CMA for setting aside ex parte order was rejected.
Was
on
rejected.
7/12/2021.
Yes, my lord.
Against that, what did you file?
Now, we have filed an appeal against the JO 5/8/2020 before this Honorable Court.
No, what is that 5/8/2020?
5/8/2020
Okay,
is
okay.
the judgment
Okay, the
passed.
money suit.
Yes, money suit.
What did you file? First appeal.
We have filed the first appeal, which was registered as RFA number 19 of 2022.
RFA 19 of?
2022.
Okay.
Which comes with IS Civil 80 of 2022. IA Civil 80 of 2022.
80.
Yes, 80. Is for condonation of a delay of 664 days. Now, this Honorable Court, via order dated 2/11/2022, condoned the delay of 664 days. Now, in the main appeal, RFA number 19 of 2022, on the same date, that is, order dated 2/11/2022, it remanded the appeal to the district court for disposal due to the pecuniary jurisdiction.
RFA was remanded back.
Yes, my lord. RFA 19 of 2022 was remanded back for disposal by the district judge. due to the pecuniary jurisdiction.
By which order?
2/11/2022.
2/11/2022.
Yes, my lord. Now thereafter, my lord, RFA number 5 of 2023 was filed before the Lanet Additional District Judge 2 with CMA number 160 of 2023, which is in pursuance of the order dated 2/11/2022 passed by this honorable court. Now it comes with CMA number 160 of 2023, that RFA number 5 of 2023. Now that CMA number 160 of 2023, in filing RFA number 5 of 2023, is for a condonation of 934 days delay. However, this CMA number 160 of 2023 was dismissed via order dated 27/7/2023. Thereafter,
Why it was dismissed?
due to default, I did not appear before the court on 4 consecutive dates
Okay.
through my counsel.
The application for condonation of delay, 160. 160, isn't it?
No, there is the number, CMA number.
Exactly.
Yes.
So you have failed to appear to conduct the condonation of delay application
Yes, my lord. Now,
on 4 consecutive days. So
Yes.
it was dismissed on 27/7.
yes, my lord. Now, without filing RSA against this order 27/7/2023, we have filed an application for readmission of the appeal. That is CMA number 672 of 2023.
CMA
Number 672,
of 20.
23, arising out of RFA number 5 of 2023. This CMA number 672, 2023 is for restoration or readmission of CMA number 160 of 2023 along with RFA 5 of 23.
Under what provision?
CMA, while filing the CMA number 672 of 2023, no provisions was made during that time. The provision was made under section 151 CPC.
Readmission.
Yes, my lord.
Okay.
Now, in fact, there is a provision, my lord, under Order 41, Rule 19.
Then what happened to your CMA?
Now, my CMA was rejected. Right order dated 30/10/23.
On what ground?
That the court, basically, it does not have any independent findings to what was passed by the predecessor court in CMA number 160. It only based its decision on the earlier order passed by the court itself, the predecessor court.
Let us see the order, 30/10/23. It's at page 22. The next one.
Page 22, yes, madam. Now, if your lordship may be kind enough to come to page 29 or page 30, para 12. That is the reasoning. if I may read this with your lordship permission.
Yes.
Page 30, para 12. After hearing the submission of the learned counsels and on scrutinizing the records available and the citations produced by the learned counsels, this court considers that whether or not omission to mention the specific provision under which the instant application for restoration was filed could be fatal for the applicant. It is difficult to overlook the lethargy and lack of interest on the part of the applicant in failure to attend personally or through counsels on 4 consecutive dates. It is on 21/4/2023, 25/5/2023, 26/6/2023, and 27/7/2023. The explanation made by the applicant in his present application does not make out any sufficient cause to justify his absence on the said 4 consecutive dates, and the justification he made in his application is neither supported by any evidence nor documentary proof. At any event, what has drawn the most attention of this court while deciding the instant application is the decision of the Honorable Apex Court in the case of so-and-so, CM Sundar Sharma versus Panalal Jaiswal, which inter alia stated dismissal of an appeal for the reason of delay in its presentation. After the dismissal of an application for condoning the delay is in substance and effect a confirmation of the decree appealed against. As petitioned under Order 9, Rule 13 of the Court would not lie in view of the filing of an appeal against the decree by the appellant, and the dismissal of the appeal though for default, since a dismissal for default or on the ground of it being barred by limitation cannot be equated with the withdrawal of the appeal. In view of the above, it is apparent from the Honorable Apex Court decision in the case of CM Sundar Sharma versus Panalal Jaiswal and others that an order dismissing the first appeal due to the dismissal of the connected condonation application has to be treated as a confirmation of the decree against which such first appeal is filed. The decision of the Honorable Apex Court mentioned above is well applicable in the instant case, since the RFA number 5 of 2023 was dismissed with the order dated 27/7/2023 by this court on the same being barred by limitation, consequent to the dismissal of the connected CMA number 160 of 2023, which is the application for condonation of the delay. Now, the understanding of the learned first appellate court would go to show that we have to file a second appeal against this 27/7/2023. Now, based on that direction, we have filed RSA before this honorable court. The RSA was registered as RSA number 1 of 2024. It was filed for challenging order dated 27/7/2023. Now, what had happened thereafter is that, my lord, your lordship will see the RSA number 1 of 2024 order, my lord.
Just a minute. See, RFA was filed by you before this High Court, but it was remanded back saying that it should go to the district judge.
Yes, my lord.
So, in the district judge, you file RFA 5 of 2023,
Yes, correct.
along with CMA 160.
My lord.
And since you did not take steps, 160 was dismissed for non-appearance.
Yes.
Accordingly, RFA also was dismissed. Against that, you filed CMA 672
For readmission.
for readmission,
Yes, my lord.
rehearing, or restoration of the CMA and the RFA.
Yes, my lord.
And that was rejected
Now that
on
was
30/10.
yes, correct, my lord.
Then after that, what did you do
Now we have come before this court.
in RSA?
Yes, against the order 27/7/2023,
Passed in?
CMA number 160 of 2023 arising
Okay.
out of RFA. Now, what was the observation made in this order 29/2024 passing RSA number 1 of 2024? My lord will kindly see at para number 15, page 37. Whether the view of the learned first appellate court was right would be settled by the observation made by this honorable court in page 37, para number 15.
In RSA, you have challenged the order dated
27/7/2023.
27/7.
That is passed in CMA number 160 of 2023.
That was dismissal of the CMA and the RFA.
Yes, yes.
Okay. Page number?
Page number 37, para 15.
37.
This was the observation of this Honorable Court made in RSA number 1 of 24. May I read with your Lordship permission?
Yes.
In the view of this court, CMA number 672 of 2023 is an application made under Order 41, Rule 19 CPC, inasmuch as it can be applied that CMA number 160 of 2023 had been dismissed under Order 41, Rule 11 or Rule 17 CPC.
What is that? Dismissed for default?
Yes, my lord. So,
Order 41, Rule 11?
yes, my lord.
Okay. Then?
Though the appellant had the opportunity to file a second appeal on the rejection of CMA number 160 of 2023 and RFA number 5 of 2023, the appellant had availed of the provisions of Order 41, Rule 19, that is readmission of appeal, for challenging the impugned order dated 27/7/2023. Unless the appellant makes a challenge to the impugned order dated 30/10/2023 passed in CMA number 672 of 2023, the appellant cannot make a challenge to the above orders dated 27/7/2023 passed in CMA number 160 of 2023 and RFA number 5 of 2023 as an appeal against the order of refusal under Order 19 of Order 41 to readmit the appeal is required. Now, coming at para 17, in view of the above provisions of the CPC, this court does not find any ground to allow the present appeal as the challenge has to be made to the order dismissing CMA number 672 of 2023. And the same has to be made in terms of Order 43, Rule 1T CPC. Now, pursuant to this formal court order, we have filed FAO against the Order 30/10/2023, which is the refusal to readmit the appeal.
Where is that?
Now, the order dated 30/10/2023 is at page 22, my lord. It starts from page 22.
Page 22.
Yes, my lord, which I have just read. Now, according to this order, my lord, passed by the learned First Appellate Court, it appears that we have to file a second appeal against the order 27/7/2023. So there was a misunderstanding of law by the learned First Appellate Court that there is a provision wherein we can be allowed to be heard under Order 41, Rule 19. Be that as it may, my lord, this honorable court in RSA 1 of 2024, Void Order dated 2/9/2024, has allowed us or has directed us to file an appeal under Order 43, Rule 1T. So we have come before this honorable court challenging the order dated 30/10/2023, which is arising out of CMA number 672 of 2023, my lord.
See, your RSA was dismissed,
Yes, my lord.
but it says that you have to challenge that order.
30/10/2023.
3010 you have to
Yes,
challenge.
we have challenged this.
And under what provision? Under Order 43, Rule 1T. Let us see what is that. Okay, so after the RSA was disposed of, in that manner dismissed, then what did you file?
Now we have filed this FAO. subsequent to the dismissal of RSA.
Okay, FAO before this court.
Yes, my lord.
Challenging the order dated
23,
3010.
which is the refusal to readmit the appeal.
Okay. Now, supposing your FAO is allowed,
My lord.
the rejection of dated 3010 is set aside.
My lord.
Then what is the next step?
According to my understanding, my lord, your lordship can set aside the 30-10-2023 and the appeal along with the condonation application can be reheard and
Because
restored to file.
that order 27-7 will remain.
Yes,
The dismissal order will still be there.
yes. But however, the readmission of the appeal, which was refused by the London First Appellate Court,
So one hurdle will be less.
100, yes.
The other hurdle will still remain.
Yes, the other hurdle would be still there. However, I would be given opportunity of being heard. That why should this 27-7-2023?
So the finding of this court in RSA was that unless the order for rehearing or readmission or restoration of that appeal
was
is,
transferred.
is interfered with,
Yes,
you cannot come straight away and file an appeal against that
27-7.
27-7.
Correct, madam. Correct.
So that's why he said you go and file under this provision.
Correct.
Today you're here
Yes, I agree.
by
FAO.
invoking that provision.
Yes.
This FAO is filed under what provision?
Order 43, Rule 1T, CPC.
Okay.
Now, the London First Appellate Court has also committed a mistake while passing that impugned order dated 27-7-2023. Instead of invoking that Order 41, Rule 19, or Rule 11, it invoked Order 9, Rule 8 CPC, which has to be in the code of the trial court at the stage of the suit. But that has been settled by this honorable court in RSA. It has made an observation regarding that.
Now let us see that provision. The dismissal was under what provision?
Order 9, Rule 8
Order 9.
CPC.
Order 9?
Rule 8.
Procedure when defendant only appears.
So this is with regard to the suit, not to the appeal.
Then for the appeal,
Order 41.
rule,
Order 41, Rule 19 is for the readmission of the appeal, and the dismissal would be Order 41, Rule 11 or Rule 17. So this has been settled by this honorable court in RSA number 1 of 2024, which made an observation that merely mentioning of the provisions of law would not make the order invalid. Order 41, Rule 17 is dismissal of appeal for appellant's default. Now, at Rule 19 is for readmission of appeal dismissed for default, Order 41.
yes.
Now, why,
Then Order 41, Rule 11, Sub Rule 2. This is also another provision.
yes, my lord. Now, why are we referring this Order 41, my lord? It's due to the fact that even though we have filed this appeal under Order 43, it's because of Order 43, Rule 2, my lord. That is, the rules of Order 41 shall apply so far as may be to appeals from orders. That is why we are referring to Order 41, even though this appeal is filed under Order 43, Rule 1T. My main grounds are that, my lord, the dates on which I was made absent was not due to my negligence. I was defended by a counsel given through legal service, my lord, in the first appellate court as well as in the trial court. However, due to the default of my counsel.
Legal aid counsel.
Yes, my lord.
Why was that?
Because he didn't have money, my lord, to engage a private.
Okay.
So,
And the appellant had filed an application for legal aid counsel?
yes, my lord. In fact, he had also filed a complaint against his legal aid counsel before the High Court Legal Service
Complain why?
because he was not properly defended, my lord.
I see.
So, he had taken action. However, that complaint against his counsel, the findings we do not know till date. So, our main grounds is that the dates in which the learned First Appellate Court has shown us to be absent is not willful or deliberate. Your Lordship will come at page 143 to 147.
Page?
Page 143.
143.
Which is the daily order sheet maintained by the learned Additional District Judge 2.
Page 140?
143, my lord. 143.
Yes.
You also will see it, the order 21/4/2023.
Yes.
The appellant or the applicant is absent. Court is adjourned. Fixed 25/5/23 for appearance of parties. Your Lordship will see at the left-hand side of the column, there is no summon issued. Again, your Lordship will see at page 144, 25/5/23.
No, what do you mean, no summon?
Here, the appellant is absent. Neither there is no mention of the respondent being present. Court is adjourned. Fixed for appearance of parties. Now, here, the appellant had no chance. The appellant himself had no chance to know these proceedings. 25/5/23. It again fixed on 25/5/2023. Coming at page 144, my lord, there is the order 25/5/23.
Yes.
On 25/5/2023, counsel for the respondent appears and submit vakalatnama. Here, the learned First Appellate Court made an observation that the appellant has been absent quite often. He is directed to state as to why the application shall not be dismissed for non-appearance. Again, my lord, I'm asking myself a question that in the left-hand side column, there is no summon issued by the learned First Appellate Court on this date as well, even though there is a mention that he was absent quite often.
No, should there be an order for summon?
Yes, my lord, there has to be a summon. Now I'll come to that order 5 rule 3 CPC, my lord.
Summon to whom?
Summon to the appellant himself.
Then if the respondent appears like that without summon, why should there be a summon for the appellant?
Because I was under the impression that my counsel would be there for me.
That's why, your counsel is there, that's why a summon should be there.
So my counsel was absent here, my lord, in this court date, the days which was mentioned by the Land First Appellate Court.
See, you're the engaged counsel in this FAO.
Yes, my lord.
Supposing you were absent last week, you are absent today also. Should we summon to your client? Something like that.
No,
Because we know that Mr. Silal Faxwala is the counsel for the appellant.
yes, my lord.
So why should we issue summon?
Now, my lord, there has to be a summon envisaged under Order 5 Rule 3 CPC if the court requires the personal presence of the appellant himself.
Why should it require
Here, my lord,
when they have already engaged a counsel?
correct. I agree with your lordship on that. If your lordship will see 21-4-23 order, it fixed 25-5-23 for appearance of parties.
So the counsel is also supposed to go and have a look at what is the order passed today. I could not appear.
Correct, correct.
Let me find out.
That is
We'll
what,
go and check up. And I think there's a cost list also.
yeah, they used to make a cost list.
There's a cost list
Yes.
also.
My lord.
So court cannot issue summon or notice to each and every individual.
Correct.
Counsels are there, they're engaged, so they're supposed to go and, now if you say that your counsel was not defending you properly, never took any step, that's something else.
Yes,
But
we have
ordinarily, the court is not required to issue a summon order to a particular person, just because counsel did not appear.
I agree.
But there are instances, of course, even in this court, if repeatedly somebody is not appearing, then we ask the registry to send a notice to that person and fix a date,
Yes, my lord.
like that. Because we don't want the client to suffer,
Correct.
just
agree.
because of the default of the person.
There
Now,
is-
here's a case, you say that according to the Learned Trial Court, First Appellate Court, on 4 consecutive days you were absent.
My lord.
What are those dates? These are the dates.
These are the dates: 21-4-2023, 25-5-2023, 26-6-2023, and 26-7-2023. The reason why I'm mentioning is that because this Learned First Appellate Court order does not mention that the appellant's counsel. It mentions the applicant or the appellant. That is why I have taken this ground. Now the grounds which I have taken, my lord, is at page, before I summarize, at page 11 to 19, my lord.
Just before that, just a minute. This order of dismissal, as per the order sheet, is 26-7. But you say that the order is 27-7.
Yes, my lord.
How come?
Here, your lordship will see, your lordship will see at page 40, page 40. This is the order given to us by way of certified true copy on folio. Order dated as page 40, my lord. Page 40.
Compare it with 146. 146 says 26-7. Certified copy says 27-7.
In any other case, it's 27-7 mentioned, my lord.
Signature of the judge is also 26/7.
Yes, my lord. Now, when we apply for the certified true copy, it's 27/7/2023.
Yes, you are taking me to some page?
The grounds which I have taken, my lord,
Yes.
page 11,
Hmm.
starts from page 11 to 19. Your Lordship, may kindly come at page 12.
Yes, page 12.
So he had engaged counsel in prosecuting his case either before the trial court or the appellate court. This was not properly appreciated by the learned First Appellate Court, and the learned First Appellate Court also ought not to have dismissed CMS 672 of 2023, inasmuch there are no records to show that the appellant himself was negligent or he voluntarily absented himself.
Counsel is a legal aid counsel or what?
It's a legal aid counsel, my lord.
Where is it written? It's legal aid counsel.
Your Lordship will come at page 108. Page 108.
One 108,
Yes, my lord.
Annexure 11.
Yes, my lord.
This talks about the High Court,
Yes,
but the order passed is before the trial court.
correct, my lord. He had also engaged there in the First Appellate Court.
Sorry?
He had also engaged Mr. Joseph in the First Appellate Court,
How? Separately?
separately, but not by
Not-
way of,
not-
not
not
by way
legal.
of paying fees.
Not by way of?
Paying fees.
No, this order, page 108, is an engagement of this particular counsel before the High Court.
Correct, correct, my lord.
Now, the order which you have challenged is an order passed by the lower appellate court,
Correct.
wherein this person was not engaged as a legal aid counsel.
No,
If he appeared, he appeared on his own.
since he was already engaged by this order, my lord, page 108. Now, out of good sense and humility, he had also appeared for him, my lord, without taking
Okay.
any necessary fees.
Okay, okay. Okay, let's go to the grounds. Ground number 1 and 2 is same, nothing to
Yes,
be
ma'am.
seen. Number 3 speaks about what?
Number 2, the learned First Appellate Court could have satisfied itself that the appellant herein was not properly represented by his counsel in prosecuting his case either before the trial court or the appellate court in money suit number 138 of 2018 and RFA 5 of 2023. Now, at para 3, my lord, the learned First Appellate Court ought not to have dismissed CMA number 672 of 2023 because there are no records to show that the appellant himself was negligent or voluntarily absented himself in not appearing before the court at the time of hearing. Your Lordship will see at the last para, 1, 2, 3, 4 lines from the last para, a perusal of the daily order sheet 21/4/23, 25/5/23, and 26/6/23, and 26/7/23. It can be seen that the appellant was neither summoned by the court nor informed by his counsel to appear before the court. para 4,
Hmm.
it was a reiteration of para 3.
Yes.
Now, here we have also mentioned that there is nowhere which shows that the applicant himself was summoned by the court nor informed by his counsel to appear before the court. The reason why I'm saying is that in those daily orders, the learned first appellate court mentioned the applicant, not the applicant's counsel. That is the reason why we have specifically taken this ground. Now at para 5, which is for a suit, the learned first appellate court fails to satisfy itself that summons were duly issued to the appellant in terms of Order 5, Rule 3, before passing the impugned order, my lord. Then the corresponding provision would be Order 41, Rule 19. Here, what's Order 5, Rule 3 CPC, my lord? My lord may kindly come to Order 5, Rule 3 CPC. Even though it relates to a suit, though this is a summon, provisions relating to summon. Order 5, Rule 3. May I read, my lord? Where the court sees reason to require the personal appearance of the defendant, the summons shall order him to appear in person in court on the day therein specified. Where the court sees reason to require the personal appearance of the plaintiff on the same date, the personal appearance, it shall make an order for such appearance. So, taking these provisions into account, the learned first appellate court could have satisfied itself that while requiring the presence of the applicant, a summon or an order by the court itself is required to be made, my lord. For my benefit, my lord, if I may just read Order 41, Rule 19.
Read.
Where an appeal is dismissed under Rule 11, Sub-Rule 2 of Rule 17, the appellant may apply to the appellate court for the readmission of the appeal, or where it is proved that he was prevented by any sufficient cause from appearing when the appeal was called on for hearing, or from depositing the sum so required. The court shall readmit the appeal on such terms as to cause or otherwise as it thinks fit. Now, the first appellate court has ample power to readmit the appeal, even to the extent of imposing costs. Now, the grounds which we have taken under Order 5, Rule 3 is with regard to summon. It was incumbent upon the learned first appellate court to first satisfy itself whether the appellant himself knows about the proceedings, my lord. Your lordship may kindly come at page 14, that is continuation of my grounds, para 6. The learned first appellate court has blindly relied upon the order dated 27/7/2023 and has not applied its judicious mind and has also failed to appreciate the facts in a proper perspective. The order passed in 30/10/2023 was that the appellant has to file a second appeal. So it has misdirected us to file a second appeal. However, this honorable court has made a finding and observation that you have to file an appeal under Order 43, Rule 1T, challenging Order 30/10/2023. Now, my lord, at para 7, the Honorable Apex Court, which I would also produce the citation, my lord.
1 minute, this paragraph 6. What is this Shyam Sundar Sarma's case?
Shyam Sundar Sarma case is with regard to that. I'll just read, my lord. Dismissal of appeal, my lord. It's with regard to dismissal of the appeal on default or withdrawal of appeal. That is the case which was taken up in CM Sundar case. Which, according to us, is not connected to the present case.
You have the judgment, Shyam Sundar.
Yes, my lord.
This is regarding cases dismissed for default.
Yes. There is a case filed under Order 9, Rule 13, and simultaneously an appeal was filed. Page 60, my lord. I have annexed in this FAO, my lord.
Which paragraph is relevant?
Now, your lordship will come at page 62, para 8.
Page 62.
Page 62, para 8.
Yes, please read.
The first question to be considered is whether an appeal accompanied by an application for condoning the delay in filing the appeal is an appeal in the eye of the law. When the application for condoning the delay in filing the appeal is dismissed and consequently the appeal is dismissed as being time-barred by limitation in view of Section 3 of the Limitation Act, there was a conflict of views on this question before the High Courts. But the Privy Council in Nagendranath Dey versus Suresh Chandra Dey held there is no definition of appeal in the Civil Procedure Code, but their lordship have no doubt that any application by a party to an appellate court asking it to set aside or reverse a decision of a subordinate court is an appeal within the ordinary acceptance of the term, and that is no less than appeal because it is irregular or competent. These observations were referred with approval by this court in Raja Kulkarni versus State of Mumbai. The specific question involved came to be considered by this court in Melaram and Sons versus CIT. This court held that an appeal presented out of time is an appeal, and order dismissing it as time-barred is one pass in an appeal. This court referred to and followed the view taken by the Privy Council and by this court in the two respective decisions above referred to. This court quoted with approval the observations of Chakla CJ in KK Porbundarwala to the following effect. Although the appellate assistant commissioner did not hear the appeal on merits and held that the appeal was barred by limitation, his order was under Section 31, and the effect of that order was to confirm the assessment which had been made by the income tax officer. I'll come to para 10, Malot. The question was considered in extenso by a full bench of the Kerala High Court in Thambi versus Matthew. Therein, after referring to the relevant decisions on the question, it was held that an appeal presented out of time was nevertheless an appeal in the eye of the law for all purposes, and an order dismissing the appeal was a decree that could be the subject of a second appeal. It was also held that Rule 3A of Order 41 introduced by the Amendment Act 104 of 1976 did not in any way affect that principle. An appeal registered under Order 41, Rule 9 of the court had to be disposed of according to law, and a dismissal of appeal for the reason of delay in its presentation after the dismissal of an application for condoning the delay is in substance and effect a confirmation of the decree appealed against. Thus, the position that emerged on a survey of the authorities is that an appeal filed along with an application for condoning the delay in filing the appeal when dismissed on the refusal to condone the delay is nevertheless a decision in the appeal. Now coming at para 12. Malon. That is what we have asked upon ourselves, my lord. That is what we have asked upon
No,
ourselves.
let us see the judgment passed
Yes.
by the learned court below.
Yes, my lord. Your Lordship will come at
Page
page 31.
31.
31.
Yes.
I'll start from the second line, my Lord. With your Lordship permission, at any event, what has drawn the most attention of this court while deciding the instant application is the decision of the Honorable Apex Court in the case of CM Sundar so-and-so, which stated, dismissal of an appeal for the reason of delay in its presentation of the dismissal of an application for condoning the delay is in substance and effect a confirmation of the decree appealed against. A petition under Order 9, Rule 13 of the court would not lie in view of the filing of an appeal against the decree by the appellant and the dismissal of the appeal though for default, since a dismissal for default or on the ground of it being barred by limitation cannot be equated with withdrawal of the appeal. Now here, according to my understanding, when an application under Order 9, Rule 13, my Lord,
No, what this order was passed in, just a minute. What was challenged in this case? For restoration, isn't it?
yes, my Lord.
This was for restoration.
This order is for the refusal.
Application for was restoration
Yes,
because it was dismissed for default.
yes, my Lord.
Under the wrong provision, but nevertheless it was dismissed for default.
Correct.
So this was, application for was for restoration. While deciding the application for restoration, reference has been made to Shyam Sundar,
Yes, my Lord.
and wherein it says that under Order 9, Rule 13, would not lie.
So when the appeal was first filed and it was dismissed, Order 9, Rule 13 could not be filed. So that was the observation made in CM Sundar case. So in our case, it's a different thing. We have filed
You have filed,
first Order 9, Rule 13, challenging the main order which was passed in money suit, which was passed in the original money suit, 5/8/2020.
your application CMA 213 of 2022 was under Order 9, Rule 5,
Rule 13.
Rule 13,
That was for setting aside the ex parte decree.
correct. So if this observation was there in that application, it would have been okay,
Yeah.
but not in an application for
Restoration.
restoration.
Yes, correct, my Lord. I agree.
So,
So it misdirected us to file a second appeal. Now there is an observation which Your Lordship, I have apprised Your Lordship about this, that is RSA 1 of 2024, which this Honorable Court has directed us to file an appeal under Order 43, Rule 1T, against Order 30/10/2023.
your CMS 160 of 2023 was for delay condonation.
Correct, my Lord.
It was dismissed.
Dismissed.
Uh,
And the RFA was also dismissed.
delay was not condoned.
Delay was not condoned.
No, it was due to, was it due to default or?
Absence, yes, my Lord.
Okay. But then the observation here is that since the order dated 27/7, passed by this court on the same being barred by limitation.
Yes, due to my absence, the observation was made.
Limitation was not gone into, isn't it?
Yes.
The question of limitation was not gone into.
It was basically due to my absence.
Default, it was due
Yes,
to
my
default, due to absence.
Yes, that is the main crux, my lord.
42.
Now, with your lordship permission,
Just a minute.
my lord.
I'll just have a look again. Accordingly, CMA so-and-so and RFA 5 is dismissed on ground of continuous non-appearance of the applicant in terms of Order 9 Rule 8.
Correct, my lord.
But yet here the observation is that order was passed dismissing the application because it was barred by limitation. All right.
With your lordship permission, coming back to my submission, my lord. Para 7, which I have mentioned.
The grounds.
The grounds, my lord.
The grounds, para 7.
Page 14, my lord.
Yes.
Now, I have relied upon the Honorable Supreme Court judgment. Here in Balakrishna case, the Honorable Supreme Court has made an observation that the primary function of the court is to adjudicate the dispute between the parties and to advance substantial justice. At paragraph 12.
This is on delay.
However, my lord, this also covers my case. Because here it made an observation that the court is to adjudicate the dispute between the parties. Here, if I'm not allowed to be heard before the learned First Appellate Court, I would be foreclosed from putting forth my case, my lord. That is the reason why I'm submitting this. Now at para 8, which I would
See,
submit to citation.
one aspect of your argument was that applicant is absent or appellant is absent.
My lord.
Doesn't say applicant's counsel is absent.
Yes, correct. I agree.
So I had no knowledge. My counsel did not attend my case. I had no knowledge. Why should I suffer?
I agree.
Why a notice or summon was not given to me?
My lord.
That is one part of your argument.
Correct.
Now the other part is that if the delay is not condoned, I will have no opportunity to project my case. My entire case will be foreclosed. My entire chances of making out my case will not be available to me. Everything will be foreclosed.
Yes, my lord.
These are two separate things.
That was what is out to be submitted before the learned First Appellate Court. But for my benefit, my lord, if your lordship may pardon me, I'm just mentioning that. Now, in the case of Sangram Singh, my lord, Sangram Singh versus Election Tribunal, 1955, SCC Online, SC 21. Even though this is an election petition, the Honorable Supreme Court has made an observation, my lord, regarding the procedural aspects of CPC. Page 4, para 16, 17. I'll read this with your lordship permission. Page 4, para 16.
Para 16, yes.
Yes, ma'am. Now, a code of procedure must be regarded as such. It is procedure something designed to facilitate justice and further its end, not a penal enactment for punishment and penalties, not a thing designed to trip people up. Too technical a construction of section that leaves no room for reasonable elasticity of interpretation should therefore be guarded against, provided always that justice is done to both sides, lest the very means designed for the furtherance of justice be used to frustrate it. Next, there must be ever present to the mind the fact that our laws of procedure are grounded on a principle of natural justice which requires that men should not be condemned unheard, that decisions should not be reached behind their backs, that proceedings that affect their lives and property should not continue in their absence, and that they should not be precluded from participating in them. Of course, there must be exceptions, and where they are clearly defined, they must be given effect to. But taken by and large and subject to that proviso, our laws of procedure should be construed wherever that is reasonably possible in the light of that principle. At para 18, my lord, Your Lordship will see 9 lines from the top, the observations of the Privy Council. The observations of the Privy Council in Balakrishnan Udayar versus Vasudeva Iyer, and especially in TM Bharat versus African Products Limited, where Lord Buckmaster said no forms of or procedures should ever be permitted to exclude the presentation of a litigant's defense. Also, Hari Vishnu case, which we have just quoted, in our opinion, Wallace J was right in Venkata Subaya versus Lakshmi Narasimham in holding that one cardinal principle to be observed in trials by court obviously is that a party has a right to appear and plead his cause on all occasions when that cause comes on for hearing. It follows that a party should not be deprived of that right, and in fact the court has no option to refuse that right, unless the Court of Civil Procedure deprives you of it. Now, these matters of adjudication before the trial court is with regard to immovable property, where I am presently residing, my lord, which is the property I inherited from my father, mother. It affects my right under Article 21 of the Constitution of India as well. Your Lordship may kindly see the Honorable Court judgment of the Honorable Supreme Court, 2013 1 SCC 353. That is on the aspects of Article 21. Even though this is with regard to Article 300A, land acquisition, but nevertheless, this is important because it affects my right, my immovable properties. If I'm not given a chance to prosecute my case in the trial court and the appellate court, I would be deprived of my immovable property, my lord. Page 361, para 17.
Yes.
Depriving the appellants of their immovable properties was a clear violation of Article 21 of the Constitution. It is the only statement which I would like to rely upon, my lord. And at para 14, my lord, page 360.
Yes.
Placanta E, my lord. When substantial justice and technical considerations are pitted against each other, the cause of substantial justice deserves to be preferred, for the other side cannot claim to have a vested right in the injustice being done because of an undeliberate delay. In my case, if I am not allowed to prosecute the appeal, that means substantial justice would be trampled upon, my lord. Your Lordship knows that appeal is a valuable right of the appellant, and it would be in the interest of justice that both parties are heard on merit, and the appellant himself herein may be given a chance to prosecute his appeal, and he should not be condemned, my lord.
Okay, I'll come back in 5 minutes.
My lord. permission, I'll sum up my argument.
Just 1 minute. Before that, where is this order passed in your application 213, CMA 213? For setting aside the ex parte order, you had filed one. Order dated 7/12/2021. Is it available here?
It's in page 105.
105. Okay. Then you filed RFA 19 of 2022
Yes, Malad.
before this court, isn't it?
Malad.
Where is the order passed? Page RFA 19. I think 109.
Yes, Malad. 109.
Then after remand, you filed the RFA 5
Malad.
with CMA 160,
Yes.
which was dismissed on account of non-appearance. Against that, you file RSA.
Yes.
RSA said that you can file
Appeal.
an appeal under
Order 43.
Order 43,
Rule 1T.
Rule 1,
T.
small t.
Yes.
Yes, please sum up your argument.
Yes, Manoj. I'll just produce citation, Manoj. In civil appeal number 1463 of 2019.
You're relying upon some other citation.
Yes.
I thought you were summing up.
Yes, I'll just sum up with this citation, Manoj.
Okay.
Page 10, para 22.
Yes.
With your lordship permission.
Yes, yes.
In our view, the courts below should have seen that the first appeal is a valuable right of the appellant, and therefore the appellant authority was entitled for an opportunity to prosecute their appeal on merits. If the appellant's advocate did not appear, maybe for merit reasons, the court could have imposed costs on them for restoration of their appeal to compensate the plaintiff instead of depriving them of their valuable right to prosecute the appeal on merits. This judgment had also relied upon that Sangram Singh case, Manoj. Now, in 2008, 13 SCC 395, page 400, para 24, Manoj. At the same time, however, when a party engages an advocate who is expected to appear at the time of hearing but fails to appear, normally a party should not suffer on account of default or non-appearance of the advocate. It has also relied upon Rafiq versus Munsilal case. Now in 2005 3 SCC 752, that is Lipok Out's case. Page 760, para 15 placenta D. Page 760 placenta D. The court should decide the matters on merits unless the case is hopelessly without merit. This is what I'm relying upon. So in the present case, my lord, I'll sum up my case.
Yes.
The learned First Appellate Court could not have dismissed our case by order 30/10/2023. It should have satisfied itself that the appeal is a valuable right granted to the litigants, my lord. So in this case, two technical to be adopted by the learned First Appellate Court would not serve justice, my lord. So here in our case, technical and substantial justice are pitted against each other, my lord. So the learned First Appellate Court could have considered this aspect, my lord. Now, looking at the Honorable Supreme Court judgment and appreciating what has been observed in the Honorable Supreme Court judgment, my lord. It is, according to us, it is a fit case where we have the right to be heard on merit, my lord. So we beseech this Honorable Court to set aside the order dated 30/10/2023 and allow us to prosecute our appeal on merit. So with your lordship permission, may I be allowed to counter my learned friend's submission at the relevant time.
This impugn order 3010, have you annexed a Xerox copy? Where is it? It's at page 22, I think.
Yes, ma'am.
Okay. 22 onwards.
Because this impugn order 30/10/2023 does not have any independent findings. It simply relied upon the order 27/7/2023. So that is my case, ma'am.
All right. Mr. Birla.
May I start, my lord?
Yes.
Your lordship, learned First Appellate Court didn't commit any illegality or wrong in passing the present order, my lord. Because due to the fact that your lordship, on two grounds, it was dismissed, which is impugned to the present appellant. Order was passed on two grounds. The first ground is that there is no sufficient reason for restoration of the application, restoration of the appeal. RFA 5 of 2023. And on the top of that, my lord, the main reason is that as the law laid down by the Honorable Apex Court in Shyam Sundar Sharma case, if the appeal, the first appeal is dismissed on the ground of delay, application for condonation of delay which was not allowed, then that appeal itself, that order dismissing the appeal on the ground of the same being barred by limitation, has to be treated as the decree, confirmation of the decree passed by the learned trial court, and it could be challenged only by filing the second appeal. That is the law. I'll come to that later in detail, my lord. That is the main reason why the application for restoration was dismissed. And another ground is that there is no sufficient ground for absence of for the 4 consecutive times.
Second is on
Absence of sufficient grounds to restore the appellate appeal as well as application for condonation of delay.
Number one, you said two grounds. One is no sufficient reasons for
Yes.
restoration. Number two is
Dismissal of the first appeal on the ground of the same being barred by limitation is to be challenged by way of second appeal only in CM Sundar Sharma case.
that is your first ground.
First ground. I'll come to that first.
You said
That is
two.
Two.
That's why
Yes.
you have not started with the second one.
Yes, the first
Okay.
one I'll come because it is the technical issue first, my lord.
Okay.
So if with your lordship's permission, I'll come to the technical issue first. My lord, there is no hyper-technical issue being involved here, and the Lanet First Appellate Court was also not in a hyper-technical view. Because your lordship, let me quickly recap the proceeding which had been drawn so far, my lord. First, although my learned friend had already mentioned about this. My lord, money suit was filed by him, by the present appellant, and it was decreed expert. Sorry, my lord, I filed the money suit, and he was the defendant, and it was decreed ex parte because he didn't file any written statement within the stipulated period of time. Yeah, Vakala Nama was filed, my lord. The present counsel also appeared. His name was reflected.
Counsel, the respondent, the defendant engaged a counsel.
Yes, engaged the counsel.
But it
Two
was
counsels.
decided?
But
it was decreed ex parte.
It was decreed ex parte.
Okay.
They failed to file written statement within stipulated period of time.
Okay.
And then application for setting aside ex parte was filed under Order 9 Rule 13, and it was rejected, my lord. Then thereafter, appeal RFA was filed. RFA 19 of 2022 was filed in this honorable court. Then which was due to pecuniary jurisdiction, and liberty was given to the present appellant to approach again the Lanet district judge. And then the present RFA 5 of, present RFA in the sense, my lord, RFA 5 of 2023 was filed. Then thereafter, we along with the condonation application, my lord. And while it was pending, delay condonation application, that is CMA 160 of 2023 was dismissed due to non-prosecution. And as a result, my lord, RFA 5 of 2023 was also dismissed. Not on default, that is very important, my lord, not on default, but the same being barred by limitation. My learned friend has said that it was default, it was dismissed on default, but it wasn't that, dismissed on default. I'll come to that order itself.
You have to show me the order.
Yes, my lord. I think it is not annexed to the memo of appeal, it was annexed to the IA, my lord, connected IA, which was already disposed of.
Order person, the RFA.
RFA. And in the CMA 160 of 2023.
CMA 160, I think, is at page 42.
42, my lord. Let me check, my lord. Forty-two in the memo of appeal is RFA 5 of
No, it's a
2020.
common order, Mr. Pillar Mena. If you have the memo of appeal with you,
Yes, my lord.
please come to page 44.
Yes, my lord. Yes, it is here, your lordship.
Accordingly, CMA 160 and RFA 5 are dismissed.
Yes. Yes, my lord. So, my lord, let me come directly to page 43. This page 43, my lord, the second paragraph means reiterated, reproduced the contents of the order passed in the condonation application, CMA 160 of 23. And it was due to non-prosecution, CMA was dismissed. And the last paragraph, page 44, my lord. In view of the above dismissal of the CMA number 160 of 2023, and as this RFA is barred by the law of limitation on the ground that there is 934 days delay, this RFA stands dismissed. So, appeal was not dismissed on the ground of default of appearance, my lord, but it was dismissed on the ground of the same being barred by limitation. So there is a difference.
Yes.
Still, in spite of that, my lord, the application for restoration was filed under Order 41 Rule 19. I'll come to that later. Now, I would like to dwell upon this Honorable Apex Court's decision, Your Lordship, in Shyam Sundar case. Because Shyam Sundar Sharma case is very similar to the present case. Let me explain what is the issues involved in that case, my lord. My lord, in Shyam Sundar case, it is very similar to the present case. The plaintiff filed suit, and then the suit was decreed ex parte. And the plaintiff, being aggrieved, filed an order for setting aside ex parte under Order 9 Rule 13. And at the same time, after that, he also filed an appeal under Order 41. That is a regular first appeal, to set aside the ex parte decree. Then 2 proceedings were there. And thereafter, while application for setting aside ex parte order was still pending, appeal was dismissed on default. Dismissed due to non-prosecution. And thereafter, my lord, application for condonation of delay was also there, filed along with that appeal in that case.
To prefer the appeal.
To prefer the appeal. And it was dismissed, application was dismissed, and accordingly RFA was also dismissed on the ground of the same being barred by limitation. And thereafter, there was a pressure for disposal of application for setting aside ex parte order. That was also dismissed by the trial court on the ground that appeal, which had already been filed, was dismissed. Then it was that the High Court was approached by the plaintiff.
Appeal was filed against what?
The
Ex parte decree.
appeal was filed to against that ex parte decree, my lord.
Okay.
At the same time, that first application for setting aside ex parte order was also filed by the plaintiff in Shyam Sundar case. And the High Court, it went.
So
yes.
two steps were taken. One was to set aside the ex parte order,
Yes.
and another one was file an appeal
Yes.
against the same order
Yes. Exactly, my lord. So appeal
before the
was-
appellate court.
Yes. Before
One
the
was
appellate-
before the
trial
same court,
Yes.
same court
Same
for ex
court.
parte degree.
Yes.
The other one was before the appellate court.
Appellate court. So
So appeal was dismissed earlier.
first, yes.
Then the application came to be dismissed again.
Yes, application was dismissed on the ground that appeal had been dismissed. So, but the contention of the plaintiff was that it was not dismissed on merit, because as per his contention, my lord, Order 9 Rule 13 says that, in the explanation says that, any order passed dismissing the appeal except for withdrawal of the appeal, the application for setting aside ex parte order could be taken up. If it was dismissed on the ground of it was disposed on the ground of the same being withdrawn. But if explanation says that if any other reason, if any other order for dismissal of the appeal, then application could not be proceeded. That was what the explanation said. So, but the contention of the plaintiff was that it was not disposed on merit, so it should be considered as equivalent to withdrawal of the appeal. But the Supreme Court, it went to the Supreme Court, up to the Supreme Court. The Honorable Apex Court in Shyam Sundar Sharma case says that it has to be treated as the decree which is to confirm the trial court's decree. So it can be, to that extent, my lord, it had been clarified. So let me come to the relevant para. It will be, I think it will be more clear if I read out, your lordship.
Shyam Sundar.
Shyam Sundar case.
Is this annexed here?
Yes.
Page 60.
The relevant para is para 8, 9, 9.1, 10 and 15, my lord.
Para 8.
8, 9, 9.1, 9.1, 10 and 15.
9.1, then 10.
Yes, then 10
Then
and
15.
15, my lord. Your lordship, I'll come directly to para 8.
Yes.
These are short ones, my lord. I'll
Yes, read.
read out. Para 8. The first question to be considered is whether an appeal accompanied by an application for condoning the delay in filing the appeal is an appeal in the eye of the law. When the application for condoning the delay in filing the appeal is dismissed, and consequently the appeal is dismissed as being time barred by limitation in view of Section 3 of the Limitation Act. I'll skip this part, my lord. I'll come to 9, para 9. The specific question involved came to be considered by this court in Mela Ram and Sons versus CIT. This court held that an appeal presented out of time is an appeal, and an order dismissing it as time barred is one passed in an appeal. And 9.1. In Shodon Singh versus Dario Kunwar, rendered by 4 learned judges of this court, one of the questions that arose was whether the dismissal of an appeal from a decree on the ground that the appeal was barred by limitation was a decision in the appeal. This court held in so and so, we are therefore of opinion that where a decision is given on the merits by the trial court and the matter is taken in appeal and the appeal is dismissed on some preliminary ground like limitation or default in printing, it must be held that such dismissal, when it confirms the decision of the trial court on the merits itself, amounts to the appeal being heard and finally decided on the merits, whatever may be the ground for dismissal of the appeal. And my lord, para 10. The question was considered in extenso by full bench of the Kerala High Court in Thambi Matthew. Therein, after referring to the relevant decisions on the question, it was held that an appeal presented out of time was nevertheless an appeal in the eye of law and for all purposes, and an order dismissing the appeal was a decree that could be the subject of a second appeal. It was also held that Rule 3A of the Order 41 introduced by Amendment Act 104 of 1976 to the court did not in any way affect the principle. An appeal registered under Order 9 of Order 41 of the court had to be disposed of according to law, and a dismissal of an appeal for the reason of delay in its presentation after the dismissal of an application for condoning the delay is in substance and effect a confirmation of the decree appealed against. Thus, the position that emerges on a survey of the authorities is that an appeal filed along with an application for condoning the delay in filing that appeal, when dismissed on the refusal to condone the delay, is nevertheless a decision in the appeal. It is clear from this paragraph, my lord. I think it's not necessary for me to come to para 15. So it should be treated as a decree passed in the first appeal. And in order to make this more clear, my lord, I may be allowed to produce one judgment of the Honorable High Court of Delhi, my lord. The reason why I'm
ultimate finding of this court, Supreme Court.
my lord, para 15. Para 15 is the
Just read
my lord, yes.
15 and 16.
Yes, my lord. We are not impressed by the argument of the learned counsels for the appellant that decision in Rani Chowdhury case requires reconsideration. On going through the said decision in the light of the objects and reasons for the introduction of explanation to Order 9 Rule 13 and the concept of an appeal as indicated by the Privy Council and this court in the decisions already cited, the arguments that an appeal which is dismissed for default or as barred by limitation because of the dismissal of the application for condoning the delay in filing the same should be treated on a par with the non-filing of an appeal, or the withdrawal of an appeal cannot be accepted. The argument that since there is no merger of the decree of the trial court in that of the appellate court in a case of this nature, and consequently the explanation should not be applied, cannot be accepted in the context of what this court has earlier stated and what we have noticed above. Thus, in the case on hand, we find that the trial court, the appellate court, and the high court have rightly held that petition under Order 9 Rule 13 of the court would not lie in view of the filing of an appeal against the decree by the appellant and dismissal of appeal, though for default, since a dismissal for default or on the ground of it being barred by limitation cannot be equated with a withdrawal of the appeal. Consequently, decision of the High Court is affirmed and this appeal is dismissed. In the circumstances of the case, we make no order as to cause. So this is intertwined with, my lord, the application under Order 9 Rule 13. But the main issue is that Order 9 Rule 13 application was dismissed by the trial court in this case, saying that appeal was already dismissed by the first appellate court. So explanation to Order 9 Rule 13 says that if it is dismissed other than withdrawal of the appeal, then application for setting aside ex parte, application under Order 9 Rule 13 cannot be taken up. So it was...
See, there were two things. One is the application under Order 9 Rule 13.
Yes.
The other one is an appeal.
Yes.
So appeal already dismissed.
Yes.
With condonation of delay, maybe for default or whatever reason may be,
Yes.
it was dismissed.
Yes.
So an application under Order 9 Rule 13 will not lie.
Will not.
This is what the Supreme Court is saying.
No, my lord. Yes, will not lie. That is very true, my lord. So
Appeal already dismissed.
already dismissed.
So restoration cannot be permitted. It doesn't lie,
Yes.
it says.
But the
But
issue...
in the instant case, the Order 9 Rule 13 was dismissed. Thereafter, appeal was filed against that order. So that difference is there. I think.
No, my lord, that is true. Yeah, I'm with your lordship, I understand that. But the present issue involved in Shyam Sundar Sharma case is that the crux of the matter is, my lord, the contention of the plaintiff while filing an application under Order 9 Rule 13 was that dismissal of the appeal was only on the ground of limitation. So it can be treated as similar to withdrawal of the appeal, and it cannot be treated as decision on merit. So,
Correct. See,
Yes.
on the face of it, where is withdrawal, where is dismissal? They are different things, I think. So maybe in Shyam Sundar that was the case, trying to project that these two are same. But otherwise, once the person withdraws the application or appeal, whatever, it's withdrawn.
Yes.
At his own free will, he is withdrawing it. The other one is because of time bar or because of default, court is saying nothing doing, we dismiss it. These are two different things.
and I understand, my lord. However, two issues are dealt with in the present case. There is, while mentioning about Order 9 Rule 13 rejection, correctly rejected due to that appeal already dismissed. But another issue is dealt here, my lord. That is, once the appeal is dismissed, first appeal is dismissed on the ground of the same being barred by limitation, and that is also decree. That is what it is mentioned it clearly. So, in order to support my contention, my lord, it has to be challenged by way of filing second appeal under Section 100. It is not clearly mentioned here, although it can be presumed and it implies that. So, let me produce that Delhi High Court's decision, my lord, with your permissions, with your lordship's permission.
But
my lord.
you see, you're saying that second appeal will lie.
Yes.
Against which order?
Against this dismissal of the first appeal, which is intertwined with that dismissal of the condonation.
That is RFA 5.
Yes, RFA 5, my lord.
RFA 5 and CMA 160.
Yes.
This dismissal against that RSA will lie.
Yes. That is what it says. So,
Then this RSA was filed before this court against which order?
against that
There was an RSA also.
rejection of the restoration application. Not this RFA dismissal order, my lord.
Against restoration,
Dismissal of the restoration application. If restoration application was dismissed, that order is appealable order, my lord, under order 43.
I think
Rule 1D.
Maranathan has been mistaken, my lord.
No, my lord.
If your lordship will see the order of this court, page 33,
which order is that?
RSA, order
This-
29, 2022,
This is against which order?
27-7. 27-7, 2023,
33.
page 33.
27-7.
So the observation was
Huh.
made.
Okay, so I'll just ask Mr. Bilal Ramenga. You said second appeal should be filed.
Second
But
appeal should be filed.
appeal was already filed. And this is the answer which court gave.
No, my lord.
That you file order 43, rule 1T.
No, my lord, my contention at that time was that they had preferred filing of the restoration application.
They had preferred?
Filing of restoration application. That is CMA number 25672 of 2023. Restoration of the appeal. So that was dismissed. So unless and until the dismissal is challenged first, then they cannot file the second appeal. That was what I say. I raised that ground before this honorable court, and this honorable court was also with me, my lord. And it says that, this honorable court say that, yes, dismissal order should be challenged first. Unless and until dismissal for default, that restoration of that application.
So that is
Yes.
why today they
Yes.
are here under order 43, rule 1T, challenging this dismissal for readmission or restoration.
Yes. And so the Lanet First Appellate Court exactly said that, my lord, it has to be challenged by filing of the second appeal. So my contention is that let it be upheld, the present the order impugned to the present appellant. Let it be upheld, so let them file again the second appeal.
Against which order?
Against 27/7/2023.
That they will file subject to the order dated 30/10/2023 being taken care of.
My lord, what I'm
If 30/10/2023 remains, they cannot directly go and challenge that first order passed in the earlier RFA 5.
Yes.
Because this,
Understand.
because this rejection of restoration
Yes.
order remains.
It remains.
So long as the order of rejection or restoration remains, they cannot go and challenge that earlier order. So if you agree, we'll set aside this order and ask them to file their own remedy, whatever.
No, my lord, what I'm saying is that instead of setting aside this order, order 30/10/2023,
Yes.
just said that, merely said that, your lordship, they can file a second appeal against the order 27/7/2023. So it may be upheld, so then they will directly go to this honorable court by filing second appeal. It is
Second
not
appeal against which order?
against 27/7/2023. That is also what the Lanet First Appellate Court said.
No, against 27/7/2023, they have filed second appeal. They have come already.
No, at that time, my lord, at that time, this order 30/10/2023 was not taken up first. So
Correct.
that was what I raised.
30/10/2023 was not mentioned anywhere.
Yes.
Today, they want to challenge that. Unless they overcome the challenge of this 30/10/2023, they cannot file an appeal against the order dated 27/7/23.
No, my lord, there is no bar by reading this order 30/10/2023. I may take your lordship to relevant para, my lord. The relevant
No,
para.
no, I don't know what you're trying to say,
Yes.
but my understanding is that you're saying that they should file a second appeal against 27/7.
Yes.
They have already filed an appeal under 27, against that 27/7. And this court has said, you cannot challenge this order unless the order dated, so long as 30/10/2023 order remains, wherein your application for restoration was dismissed. First, that has to be cleared. If it is allowed and if that order is set aside, then the next hurdle is you have to challenge this RFA 5 of 2023 by way of second appeal. You only read that Sundar Shyam's case.
Yes.
Sundar Shyam's case says that whether it be dismissed for delay, continuation of delay, whether it is rejected on accounts of delay or not. Once the application is rejected, that means the appeal also itself has been dismissed. So it amounts to a decree.
Yes,
If it amounts to a decree, then the only remedy is you have to file it by way of RSA.
right.
So that will come at a later stage. Today we are concerned only with this 30/10/2023.
Yes. Whether it is,
Because
whether it is
council says that I engaged somebody, that somebody did not take care of that case. And court also did not look into that aspect, that because of council's default, I have been left remediless. So this is not permissible because I should be given a chance. This is what he's saying. If that is to be believed and if that is to be accepted, then this order dated 30/10/2023 will go. Then now what is the next step? Next step is that the order passed in CMA 160 and RFA number 5 of 2023 is still there,
Yes,
dismissal.
yes.
So that they'll have to challenge in accordance with law.
But your lordship,
So it has to go step by step.
I understand your lordship. However, my lord, if the present order 30/10/2023 is set aside, that means restoration application will be revived. That is what. So instead of taking up restoration application again, the first appellate court.
No.
Yes,
What do you mean restoration will be revived?
because this order. 30/10
Rejection of restoration application is 30/10/23.
Yes,
If it is set aside, then
set aside means rejection. It was rejected, and if it is set aside, that means restoration application will be taken up again, my lord. So instead of taking up the restoration application again, as per the dicta of the Honorable Apex Court, then this may kindly be upheld. Then easily they may challenge 27/7/2023, although they had challenged earlier, but that was in the presence of while this order 30/10/2023 was still there. They challenged that order 27/7. But now, if it is upheld and disposed of, that means restoration application will be gone. Then easily they can directly challenge by filing second appeal, my lord.
this restaurant application was dismissed on what ground?
On the ground that there is no sufficient ground, plus
Okay.
they have to file second appeal. So if your lordship just merely dismiss this, just merely set aside this order, then restoration application will, uselessly it will be revived again, my lord. It will come up again. So that is not the law, what the Honorable Apex Court says. So it will be much easier if it is upheld, then let them, it is a very shortcut manner, my lord. So then let them file the second appeal.
My lord, may allow me to interject, my lord. If your lordship will see this court order in RSA, paragraph 15, that observation and findings, my learned friend has tried to overcome this observation and findings. Page 37, paragraph 15.
What I am saying is that, my lord, this observation of this honorable court was that in the while order 30/10/2023 was still existing, my lord, it was not appropriate to challenge the second, to file second appeal against order 27/7. So exactly as per the instruction of this honorable court, advice of this honorable court, now they have filed this FAO to challenge that rejection order, rejection of the restoration order. But there is no wrong or illegality in that dismissal of restoration application. Because, my lord, if this is set aside, then that means the application for restoration application will be taken up again, needs to be taken up again. But all they have to do is that they have to directly file second appeal under section 100 CPC to challenge order 27/7/2023. And besides that, my lord, although I haven't come to that part, if restoration application is to be filed, then that has to be filed under order 41, rule 19, only for dismissal of default of the appeal. But it was not dismissed on default, it was dismissed due to limitation. So even that application itself was not maintainable. But the easiest way for them to follow the correct way is that this order may kindly be upheld, and so that easily they can challenge by filing second appeal as per the Honorable Apex Court's order as well as the First Appellate Court's order, which is being challenged here, my lord.
No, how they will challenge this 27/7/2023?
27/7, they can challenge because
By what provision? Under what provision?
under section 100, my lord,
Second appeal.
second appeal.
Then what was this RSA 1 of 2024 then?
It wasn't decided on merit, my lord. RSA 1 of 2024.
They have already challenged by filing this RSA 1 of 2024, invoking section 100. What did they challenge? They challenged the order dated 27/7/23.
Yes. But at that time, my
And
lord,
it was dismissed. Now you are saying that let them challenge 27/7 again by filing second appeal.
it was
Again, second time. How is
it
it
was
possible?
not dismissed. It was not dismissed on merit, my lord. It was due to that wrong due to the fact that the order dated 30/10/2022 was still there at that time. So they have to challenge it first. Only
So
due to that ground.
30/10/2023 is still there till today
Yes.
also. It's still there.
Still there. So now they have challenged it now, my lord. Now they have challenged it. So the only the only issue to be seen is that whether it was correctly passed or not by the learned First Appellate Court. So there is no wrong or illegality because that 27/7/2023 could be challenged by way of filing the second appeal only. Although they had already filed, it was not decided on merit, my lord. So there is no bar for approaching this honorable court again by filing another RSA, my lord, second appeal. Because it could not be taken as res judicata.
They've already filed, it was dismissed. Why are you saying that they should challenge again? I don't understand.
Because, my lord, 27/7/2023 was still there. It was not taken up again. It was not dismissed by this honorable court, my lord. It was the merit, any merit of the case was not touched upon by this honorable court while deciding the earlier RSA, my lord.
It was not touched upon, that's correct. Nobody is saying it's touched upon. It was not touched upon. Why? Because according to the court, this rejection of the restoration application order is still alive. It remains.
Yes.
First of all, you have to challenge that successfully, then only the question of filing a second appeal will arise.
Nice.
Now you're saying that if 30/10/2023 order is interfered with, the restoration application will become once more alive again.
Yes. It should be taken up again, my lord.
So it will be taken up again by the court with certain observations that how it should be done. Because I don't know, I have not decided anything, but according to the applicant or the appellant, it was decided basically on the same ground by which the CMA was rejected earlier, saying because of delay and all that. Or they fall on the part of the. Anyway, you sum up, we come back at 2.
Yes.
We'll see.
Yes, my lord. continue by
Yes.
making a short submission only, my lord. Your lordship, may I take your lordship to page 37 of, this is the order passed in the second appeal.
Yes.
Because I'll come directly to the, whether the correctness of the learned trial court's, first appellate court's order only, my lord. Then I have already mentioned two grounds. And here, paragraph 16, page 37, my lord. Even this honorable court says like this: in the case of Shyam Sundar Sharma versus so-and-so, the Supreme Court held that when a condonation of delay application is dismissed by the first appellate court, which results in the appeal being dismissed, a second appeal lies from the consequential order dismissing the appeal. However, in the present case, the appellant had challenged the impugned orders dated 27/7/2023, White CMA number 672 of 2023, before filing the present appeal. An order made under Order 41, Rule 19 CPC is an appealable order under Order 43, Rule 1 T, Clause T CPC, while the present appeal has been made under Section 100 CPC. In view of the above provisions of the CPC, this court does not find any ground to allow the present appeal, as the challenge has to be made to the order dismissing CMA number so-and-so, and the same has to be made in terms of Order 43, Rule 1 Clause T CPC. The appeal is accordingly dismissed. So, my lord, it appears from these two paragraphs that even this honorable court is with the observation that it is correct in saying that dismissal of the first appeal on the ground of limitation should be challenged by filing second appeal. And so, yes, exactly, truly, the present appellant had filed the second appeal, RSA 1 of 2024. But that was dismissed only due to the ground of not being challenged, not challenging the order dated 30/10/2023 first. So now, the present appellant is challenging that order dated 30/10/2023. So, the two grounds mentioned by the learned first appellate court for dismissal of the restoration application. The first one regarding the technicality, my lord, then there is no error in deciding that it has to be challenged by filing the second appeal. Because this honorable court had also come into the conclusion by making observation at para 16, which I have just read out, my lord, saying that yes, it has to be challenged by filing second appeal, even if the first appeal is dismissed on the ground of limitation. And the second ground why it was dismissed is that, my lord, restoration application. There is no sufficient cause brought out by the appellant in his restoration application. That is, my lord, if I may kindly take your lordship to page 45 of the memo of appeal. This is the application for restoration.
Yes.
My lord, then at the course title, no particular provision of CPC was invoked. But anyway, I'll come to page 46. Para 2 is the only reason mentioned by the present appellant in one para only. By trying to make out sufficient reason, sufficient cause, my lord. I'll read this para only, my lord. That due to the miscommunication between the applicant and his counsels, the applicant's counsels were of the belief that the applicant was going to engage different counsels. As a result, they did not attend the court on 21/4/2023, 25/5/2023, 26/6/2023, and 27/7/2023. However, recently after the applicant's counsel came to know of the order dated 27/7/2023, they informed the applicant, and it was at the time of informing the applicant of the order dated 27/7/2023 that they became aware that the applicant was not engaging different counsels, and that it was a miscommunication with the applicant that made them believe that the applicant was engaging different counsels. As a result, the applicant is filing the present application for restoring RFA 5 of 2023 along with the CMA number 160 of 2023. So this particular paragraph is not supported by any documentary evidence or otherwise, my lord, in order to support this submission. Whether any affidavit from the concerned council or any communication through WhatsApp or otherwise, my lord. So this is what the learned First Appellate Court had observed, rightly observed, that this mere statement of this reason in this particular paragraph is not a sufficient cause for restoration. So, my lord, two grounds mentioned by the learned First Appellate Court, as I have stated, there is no error or wrong or any illegality. So these are the correct observation and decision had been made, my lord. And in any view of the matter, my lord, if we look at Order 41, Rule 19, CPC, my lord, this is readmission of appeal, dismissed for default. And my contention is that, my humble submission is, my lord, the RFA 5 of 2023 was not dismissed due to the default. Although application for condonation of delay was dismissed due to non-prosecution, due to default of appearance, but the appeal itself was dismissed on the ground of the same being barred by limitation. So it is very questionable whether restoration application could be filed before the learned First Appellate Court. That question will also be taken up, my lord. Because if it was dismissed on default, I'm talking about the appeal, RFA, then maybe he could invoke, although in the course title nothing was mentioned about the provision of law, but this Honorable Court in RSA order stated that the power is still there. So long as even the First Appellate Court quoted Order 9, the Order 9 rule, Order 8 Rule 13, my lord. But this Honorable Court had clarified in RSA order, saying that power is there under under Order 41 Rule 19. So even if it is presumed that it was filed by invoking that provision of law, but still it has to be invoked only in respect of dismissal of the appeal on default. So these are my contentions, my lord. So in order to examine the impugned order at this stage, there is no wrong or illegality. The only thing is that, my lord, this Honorable Court, the reason why earlier RSA 1 of 2024 was not taken up and decided on merit was due to order dated 30/10/2023, and now they have challenged. So even if by challenging this order, if we look at this order and examine the illegality or the correctness, my lord, so there is no wrong due to those 3 points that I have submitted. So it may kindly be upheld. So even if it is upheld, then now they have challenged that order 30/10/2023. So there is no bar for them to prefer the second appeal again, my lord. Even though RSA 1 of 2024 was dismissed, there can be no bar in respect of res judicata. Because the reason cited by this Honorable Court was only due to the fact that they haven't challenged first that 30/10/2023.
The appeal
My lord.
is with regard to the order passed in CMA 672,
My lord.
an order dated 30/10/2023.
My lord.
Supposing this order is not interfered with, it remains as it is
Yes.
by dismissing this FAO.
Yes.
You're saying that they can still prefer this second appeal against the order passed in CMA 160
Yes, my lord.
and RFA 5 of 2023.
Yes, my lord. Because there was no decision on merit, and apart from that, my lord, the only reason cited by this Honorable Court in dismissing RSA was that they haven't challenged it yet. He hasn't challenged it yet. 30/10/2023, and now he has challenged.
But again, back to the same old question again.
My lord.
When the RSA was filed, RSA 1 of 2024, challenging the order dated 27/7/2023,
my lord.
according to the court, unless you challenge the order passed in CMA 672 of 2023,
Yes.
how could you file this second appeal? That is why they have filed this FAO now,
Yes.
under the provision of Order 43, Rule 1T.
Yes.
You are saying that this order should be maintained and they can file their second appeal if they want to against RFA.
Yes.
But that RFA is already, I mean, second appeal was already filed.
To be honest, my lord, my humble opinion is that RSA earlier filed, that is 1 of 2024, should have been proceeded. Although I'm not saying that the order.
But the court has already
Yes.
taken a decision.
Yes.
You cannot come straight away with this appeal. First, you challenge this 30/10/2023,
Yes.
which they have done now.
Right. Still then, my lord, even despite the direction of this honorable court, now they have challenged, and in spite of that, there is no illegality in the order dated 30/10/2023. That is still my contention. my
No, that is a different thing.
lord. Yes.
Definitely, you will go by that only.
Yes.
They want 30/10/2023 to be set aside.
Yes.
You want it to be confirmed.
Right. The reason why I'm coming to the technicalities first is that it is purely technicality at the first.
So your argument that, okay, they have filed this CMA 672,
Yes.
and you have shown me their pleadings also. Number one is that there is no provision mentioned.
Yes.
Number two is that their explanation is only paragraph 2,
Yes.
some misunderstanding.
Right.
It is not backed by any documents or any material.
Yes.
Simply a statement.
Right.
So the learned court below was right in dismissing the CMA.
Yes.
That much okay. That is your ground for rejecting this FAO. But your contention saying that let them now file RSA. How will they file RSA? Since that first round already happened. Court said that you cannot file.
Because no, my lord, the reason why this honorable court said that you cannot file is that only due to that, instead of challenging first that order 30/10/2023, and now they have challenged. So there is no bar for going the second round RSA, because it wasn't decided.
If they are unsuccessful, then they can still challenge.
They can still challenge, my lord. There is no bar because it wasn't decided on merit. Res judicata cannot bar, my lord. Although I'm not prepared with that citation in that line, my lord. I think I could help this honorable court. If necessary, then I'll search for regarding res judicata.
Now, supposing this order dated 30/10/2023, challenged in this FAO is allowed, this is set aside,
Yes.
then the CMA 672 is revived again.
Revived, yes.
And parties will have to again be heard and court will have to decide again.
Yes.
Back to square one.
Back to square one.
And the court may revive it or may not revive it. We don't
Yes.
know. If
I
it doesn't revive it, then
Then they have to file another second appeal, my lord, for the second time, which is not barred by res judicata. So back to square one only. To be honest, my lord, I think although it had already been gone, but at the time when they filed the RSA 1 of 2024, I think I was under the impression that they challenged that rejection of the dismissal of the restoration application. So I raised one question before this honorable court, saying that unless that dismissal the order 30/10/2022 was challenged.
Hmm.
So how could they file the second appeal? I think my submission was in deadline, although it already gone, that part, that proceeding, my lord. As of the record, so to say, I'm just submitting. So I should have not argued that, because that RSS should have proceeded exactly as the first appellate court had mentioned in the order 30/10/2024. 2023, sorry. But still then, even if it is upheld, then there is no bar, my lord, for filing of the another second appeal for the second time.
You know, understanding of that order passed in the RSA
My lord.
basically is that since you have not challenged the order passed in 672 as per the relevant provision, so your challenge to that order passed in the CMA 160 and RFA cannot be entertained. Because the subject matter of the appeal was there only.
Yes.
RSA was filed challenging order dated 27/7/23.
Yes.
But later on the court said that CMA is there, order passed was there, restoration application was rejected. You should challenge that first under order 43 rule 1D.
Right. And my lord, even for the present appellant also, since they were not aggrieved with the order dated 30/10/2023, they exactly prefer the second appeal. And unless this honorable court's order is not there, is there, then there is no point for them to challenge at this stage also. But it was,
Okay, let us understand this way.
my lord.
RFA 5 of 2003 was filed.
Yes.
Since there was delay, CMA 160 of 2023 was also filed.
Right.
Somehow this case was not allowed because the party concerned failed to appear before the court
Right.
on consecutive dates. Court said that dismissed. Accordingly, RFA also dismissed.
Yes.
Against that dismissal order or disposal order, what is the remedy? Number one is file second appeal.
Right.
Because order passed even in miscase for non-prosecution or for non-continuation delay amounts to a decree passed in the appeal, according to the Supreme Court, Sundar Syam's case.
Correct.
So it's a decree. So you can very well file an appeal. They have filed the appeal, second appeal, section 100. But it so happened that they also filed one application for restoration, 672.
Yes.
Although there was nothing mentioned there.
Yes.
So please restore. Probably it was under the spirit of Order 41,
Rule 19.
Rule 19, in that spirit,
Yes.
for restoration, rehearing or whatever. They're also rejected.
The rejection ground was to prefer the second appeal.
In Shyam Sundar, it says that
Yes.
if the appeal is already rejected, dismissed,
Yes.
you cannot file the restoration. I don't know whether that is the correct understanding of the decision.
Order 9 Rule 30.
No, Order 9 Rule 30
No, that's
was
okay.
clearly mentioned.
Provision, there's no issue. Thing is that, according to the Supreme Court, if that dismissal of the appeal, if the appeal is dismissed, you cannot now go apply Order 41, Rule 19 for restoration. The appeal is already dismissed. This is what it said, I think, the last two paragraphs. But in this case, the appellant had first gone for that, for restoration. No, he had first went for the appeal. He had filed the appeal
Yes,
against the dismissal.
No, restoration.
No,
was
you had
first.
filed the restoration first.
Yes, restoration first.
Restoration was first.
Yes.
Restoration was rejected. So instead of challenging that rejection of restoration, you went straight and filed the appeal against the dismissal on account of non-prosecution.
Yes,
Because he was happy with the dismissal of restoration application.
Nobody says that.
Because exactly as the dismiss order that dated 30/10/2023 said, so he has filed the second appeal.
I believe my learned friend is aggrieved of the observation made in para 15, passed in RSA 1 of 20.
So can there be two remedies then?
Yes.
Once you can file second appeal, on the other hand, you can also file an application for restoration.
There is a judgment of the Honorable Supreme Court, Madam. I'll just quote it.
What does it say?
As general principle, page 650, para 8.
No, it's an interesting proposition. You see, if there are two remedies, if one fails, can you go and avail for the other remedy also? Or can you avail both the remedies at one time?
Page 650,
6,
para 8.
yes.
As a general principle, where two remedies are available under law, one of them should not be taken as operating in derogation of the other. So, my learned friend contention is that you have to file RSA against 27/7/2023. Yet again, when this Honorable Court in its order 29/2024 has directed us first to file an appeal against order 30/10/2023 by way of FAO under order 43 Rule 1T.
So now the problem is that whether it is right or wrong, whatever it may be, the order remains.
Yes, my lord.
Order passed the RSA.
Yes, it remains as it is. It has not gone to the Supreme Court till date. So it appears that my learned friend is aggrieved with this para number 15 of the findings of the RSA passed by this Honorable Court. My learned friend has skipped this para 15, page 37.
Para 15.
Yes.
Would you like to read? Para
Yes,
15?
my lord, with your lordship permission. In the view of this court, CMA number 672/2023 is an application made under Order 41 Rule 19 CPC, inasmuch as it can be applied that CMA number 160 of 2023 had been dismissed under Order 41 Rule 11 or Rule 17 CPC. Though the appellant had the opportunity to file a second appeal on the rejection of CMA number 160 of 2023 and RFA number 5 of 2023, the appellant had availed of the provisions of Order 41 Rule 19 CPC for challenging the order dated 27/7/2023. Now, it was the view of this Honorable Court that on the dismissal of CMA 160 of 2023, you should have come directly to the High Court by way of filing RSA. But instead of doing that, you have filed a restoration application. That is why you cannot overcome this. So this Honorable Court has directed us to make a challenge to order dated 30/10/2023 by filing an appeal under Order 43 Rule 1T.
Okay, what do you mean by this? Para 8, as a general principle.
As a general principle, where two remedies are available under law, one of them should not be taken as operating in derogation of the other. which means one of them is not subservient to the other provisions. Like, I can file an appeal against ex parte order under Order 9, Rule 13. Without filing for that, setting aside under Order 9, Rule 13, I can also file directly an appeal, RFA, against that order. So that is what it means, according to my understanding.
No, does it mean that you can file both?
We can choose. We can choose.
No, if you choose, supposing A and B is there, if you choose A,
Yes, my lord.
can you turn around and say that, no, I'll go for
No,
B,
that
since
is-
you have failed in A?
Yes, correct. That is what CM Sundar has decided. First, they have filed an appeal, and they have, the appeal was dismissed.
Yes.
After dismissal of appeal, they cannot file application under Order 9, Rule 13.
For restoration.
Yes, for setting aside. Setting aside the ex parte.
In your case, you
In our
filed
case, we have first filed
restoration.
setting aside the ex parte decree under Order 9, Rule 13. After the dismissal of that application, we have filed an appeal. So our case and CM Sundar case is different, my lord. It's distinguishable, my lord.
No, you filed CMS 672 for what? For readmission.
Readmission, my lord. Now, that,
No, this readmission of the appeal,
yes, my lord.
it's not regarding the ex parte.
No, it's not regarding
Ex parte is
different
way
thing.
back.
It's different thing.
After ex parte, the appeal came.
Yes.
Appeal was dismissed for default, you can say.
Yes, correct, my lord.
Then you could have filed RSA,
That is the observation made by this.
or you could file the Order 41 Rule 19.
Yes.
You have chosen to file Order 41 Rule 19.
Yes, correct, my lord. That is the observation made by this court. So my learned friend is submitting on the assumption that they have to challenge 27/7/2023 again. But as per the observation and the direction by this honorable court, we have filed an appeal under Order 43 Rule 1T, challenging 30/10/2023.
My lord, if we come to, sorry for intervention, my lord. If we come to para 16 of page 37.
If one of you submit, it's very clear. Once the other side starts submitting, it becomes more confusing.
Because my learned friend has read out only para 15, my lord, page 37.
That is what,
But
because
paras-
you have not read that out.
Para 16 stated clearly that it has to be challenged by filing second appeal only. Exactly as observed in the Honorable Apex Court in the case of CM Sundar Sharma. So, my lord, my humble submission is that, yes, if, for an example, the appeal without necessary to condone the delay, if there is only one appeal being filed, my lord, and if it was dismissed on default under Order 41, Rule 11 or Rule 17, then definitely readmission can be applied by filing restoration application under Order 41, Rule 19. Suppose there is no condonation application which preceded the appeal. If the appeal was filed within time, for an example, my lord, then it was dismissed on default, then yes, restoration application for readmission could be filed under Order 41, Rule 19. But in the present case, it was filed along with the application for condonation of delay. Then condonation of delay application was rejected, whether it was dismissed on default, but that is the application only. But due to limitation, due to the appeal, connected appeal being barred by limitation, not on the reason of dismissing on default, the appeal was dismissed. Then if it was dismissed, as the Honorable Apex Court said in Syam Sundar Sharma case, then it has to be challenged only by way of filing second appeal. So that is the difference, my lord. Then we don't have to confuse with Syam Sundar case, which was mixed up with Order 9 Rule 13 application. Because in that case, Order 9 Rule 13 application also dismissed because the appeal which was filed subsequently was also dismissed. Then the plaintiff in that case contended saying that, my lord, no, it was dismissed, it was not dismissed on merit. But Supreme Court says that, yes, even dismissal on limitation ground is also merit. So it could be considered as a decree. So that was the only mixing up of the two, that the RFA appeal, first appeal, as well as the application under Order 9 Rule 13 in Shyam Sundar case. But in the present case, my lord, it was dismissed on the ground of the same being barred by limitation, not on the ground of dismissal on default. So that is the difference.
But one thing is that, can the appeal be considered for admission if it is not filed within time?
No, Your Lordship, after the order passed in RFA 5 of 2023 stated clearly that first, the contents of the order passed in the application for condonation of delay was reiterated first, my lord.
See, Mr. Bilaramega,
My lord,
appeal is before you.
my lord,
First question is whether it's filed within time.
my lord.
If it is within time, okay, fine, we take it up for admission.
Right.
But if there's delay,
My lord.
and that delay is not condoned, there is no appeal. This is what the apex court has said. So whether you file it like out here in outlying benches I've seen, you file appeal, you file application for condonation of delay.
Yes.
Both cases are numbered. CM application also number will be there.
Yes.
Appeal also number will be there,
Yes.
numbered by the registry.
Yes.
But in the principal seat, it is not like that. The appeal doesn't have any number,
No.
blank. Only the CM application will have number. Now, only when the delay is condoned, CM application is allowed and delay condoned, then court will say, okay, now register the appeal. It's like that. So, what I'm trying to say is that if appeal is filed just like that, it is only an appeal. Okay, this is an appeal. But whether the court can take up or not, that will depend on whether the appeal is filed within time. If it is 1 day also, 2 days also late, there is no appeal. First, you have to apply for condonation.
Yes.
So you're trying to distinguish. You're saying that application was dismissed for default,
Yes.
but appeal was dismissed for time part.
Time bar.
Can it be two different things?
That is what Shyam Sundar case said, my lord.
No,
If
we'll have to go back to Shyam Sundar. Let
Yes,
us-
if we look and read it carefully, my lord, it is what it said.
Shyam Sundar. Which paragraph? In Shyam Sundar.
Relevant para is
Relevant
8,
para.
9, 9.1, 10 and 15. 8, 9.
You see, there's another aspect also.
My lord.
Now, when it comes to the apex court, SLP is filed, and the court passed an order saying that we find no ground to interfere with the order passed by the High Court, dismissed. That is one. Another order is, we have examined the order passed by the High Court, so and so and so, and on merit, we find that it does not call for interference. Hence, the SLP is dismissed. Now, there are two arguments. One says that this has been dismissed, not on merit. Supreme Court has simplified, said that I will not interfere. The other part is that everything has been examined on merit and court has upheld it. So the first part, one is not upholding, it's just saying dismissed. The second part, the second one is upholding. So there are arguments, counter arguments made before the High Court like that. Supreme Court has not decided on merit. So we have come again now before the High Court. In filing, they come back by filing review. Although Supreme Court has dismissed it, but we have come for review. Review is admissible. Why? Because Supreme Court has not decided on merit.
I see.
So these are the kind of arguments put forth. But here in Shyam Sundar, we find something else again. Paragraph 8.
Yes. And 9, 9.1, 10 and 15 are also relevant, my lord.
So what do you understand by para 16 of this judgment? They have concurred with the view of the High Court.
Yes.
Appeal file was dismissed, so the application under Order 9 Rule 13 will not be maintainable.
Yes.
Yes. So now what they have to do is to challenge the order passed in the appeal, isn't it?
Yes, by second appeal. Because it was the contention in respect of the application under Order 9 Rule 13 CPC.
What you are basically saying is that whether the instant FAO is allowed or dismissed or whatever, it does not deprive the appellants from filing an appeal against the order passed in the CMA 160 and RFF 5 of 2023.
Yes. By,
That is what you're saying.
yes, by filing second appeal.
My reply is that since that RSA was there, some observation was there in the RSA, it remains. Can this court ignore that observation of a coordinate bench? And say, no, you have made this observation, this is not correct. This is the right position.
Yes.
Will it be possible to say like that?
I don't think, my lord, yes, it may not.
So on that
Unless
point,
conflicting.
if I differ,
Yes.
or if I differ, we might have to refer it to a larger bench.
Yes.
Because for these reasons, I do not agree with this.
Yes.
Then we refer it to a larger bench.
Right.
Ultimately, that will be the step to be taken.
Mm.
Otherwise, we'll have to adopt by what the learned single judge has said. Yes, right, you're right. They have not challenged the order passed in the restoration application, so let them challenge, and we are entertaining that. And today we are entertaining that, and accordingly we are saying that the learned trial court was not right in rejecting the application just like that. There should have been more reasons behind rejection or whatever it may be. And like you said, it'll be revived again. It'll be revived again, and parties will have to go back to the same court, try to convince it. And the court again says that, no, nothing doing, I don't find any merit, again dismissed. And what do? They come back again to this court.
Yes.
In FAO again.
Endless procedure.
It goes on and on and on. But now, of course, they come back because the trial court has now given 3, 4, 5 reasons. Earlier, there was only one reason. Now the trial court has given 3, 4, 5 reasons. So again, you come back as FAO. Then what will happen?
If I may submit, my lord, if we again look at para 15 of the RSA order, now that observation is against the respondent.
What was that page? 15.
Page 37.
37.
The reason why I'm saying that it is against the respondent is because this honorable court has made an observation that it can be implied that CMA number 160 of 2023.
It says, unless the appellant makes a challenge to the impugn order dated 3010,
Yes.
passed in the CMA 6672,
Yes.
the appellant cannot make a challenge to the above
Yes.
orders dated 27. So
Now-
this has caused an impediment.
Yes. Now this honorable court has made an observation that this CMA 160 of 2023 had been dismissed under Order 41 Rule 11 or Rule 17. Now what is Rule 17, my lord? Dismissal of appeal for appellant's default. Now the observation is there that it was due to our default. It's not any other default. Since my learned friend is taking the ground that no, it's other than default. But this order is against my learned friend, the observation. Because unless this is challenged by the respondent, the observation is to the effect that the dismissal of appeal is due to the appellant's default. So that does not help my learned friend's case.
My lord, if I may, regarding that point, if we read this para 15, what my learned friend saying is that it is the observation of this honorable court saying that the application CMA 672 of 2023 could be presumed as if it was filed under Order 41 Rule 19 CPC only. But this honorable court didn't say anything whether it could be filed, whether it was lawfully filed. So still, I am able to challenge at this stage that even if it was filed by presuming that it was filed under Order 41 Rule 19, but that could not be admissible. Still, I can say like that because this honorable court didn't mention anything about the legality of whether the question of whether they could file or not. It was merely it merely presumed that it was filed as if it was filed under Order 41 Rule 19.
No, it is obiter dicta, my lord.
But whether it could be maintainable, nothing was mentioned by this
Now,
honorable court.
1, 2, 3, 4 lines from this last 15 paragraph number 15. Here it specifically mentioned, my lord, with your lordship permission, if I may read this. Unless the appellant makes a challenge to the impugn order dated 30/10/2023, which your lordship has rightly pointed out, passed in CMA number 672 of 2023, the appellant cannot make a challenge to the above order dated 27/7/2023, passed in CMA number 160 of 2023. My lord, there are two remedies here. One remedy is to file an appeal against order dated 30/10/2023 under Order 43 Rule 1T. So this is the specific observation made by this honorable court that you cannot file a second appeal against order dated 27/7/2023 unless you file an appeal against order dated 30/10/2023 because it is an appealable order under Order 43 Rule 1T. So that is the observation made by this honorable court, which has to be overcome by the respondent if they are aggrieved. Now, based on the direction of this honorable court, we have filed FAO.
Okay, anyway, we'll do one thing. We'll take up this matter again.
Yes.
Perhaps tomorrow.
Yes, my lord.
Some more understanding is required,
Yes.
isn't it? Let us not be in a hurry.
Yes, my lord.
Yes, my lord.
This is the matter again tomorrow in the admission column.
Duly obliged.
Much obliged, my lord.
Yes, you retain them, please.